Welcome everyone to this very special Morehead-Cain Alumni Speaker Series event. I'm pleased to call upon Chris Bradford, President of the Foundation, to introduce today's speaker. Chris.
Thank you so much, Megan. Welcome everyone to this very special Alumni Speaker Series with Jerry Blackwell from the class of 1984. Made more special as it's the first of the school year and indeed my first to have the opportunity to welcome you in my role as the Foundation's president. It's an honor to have you all here. I think all of us know that it's been a few days, more than 5 months, since a jury convicted the former Minneapolis police officer Derek Chauvin for the murder of George Floyd. And as a lead special assistant attorney general for that case, Jerry helped deliver the prosecution of Chauvin on all 3 counts of his indictment. I remember consuming the news on April 20th, as I'm sure many of you were, and hearing Jerry speak. I was with my wife, Genevieve. We were listening to the case's closing arguments in Johannesburg, and we heard Jerry tell the jurors that they were told that Mr. Floyd had died because his heart was too big, but the truth of the matter was that the reason George Floyd died was because Mr. Chauvin's heart was too small. And I thought that was an exceptionally powerful nature closing argument. And I learned that that wasn't actually Jerry's first high-profile case. It was the latest of many. The previous year, actually, in 2020, Jerry and his firm secured the first posthumous pardon in Minnesota history, getting a pardon for a young Black circus worker named Max Mason, who had been wrongly convicted of raping a white woman in 1920. Jerry is a nationally recognized trial lawyer. He's defended class actions, commercial disputes, a whole range of complex cases, known for distilling complex arguments into easily understood concepts. He served as national counsel for many major corporations. But I think importantly for us here at Carolina, he is a double Tar Heel, receiving his bachelor's degree in political science from UNC, as well as his JD from the University of North Carolina School of Law. He's a native of Kannapolis and also a co-founder of the Minnesota Association of Black Lawyers. Without further ado, welcome, Jerry. It's wonderful to have you with us, and we all look forward to learning from your experiences today.
I'm glad to be here, and good afternoon to everybody. I wish I could take an hour just to say hello to everybody I know and just point fingers in Zoom, but I can't do that. So I want to start off not talking about the case at all. I want to start off talking about the 1998 Grammys, because in the 1998 Grammys, there was to be a performance by Luciano Pavarotti. He was supposed to sing his most famous Nessun Dorma. And before he could go onto the stage, he was advised by his doctor that his throat was so bad he could not sing. And it just so happened that nearby was his good friend, Aretha Franklin. And they asked Aretha Franklin right there at the Grammys if she could step in. And Aretha Franklin asked, as she might, "Can I listen to his performance tape?" is what she asked. And they played the performance tape, and she got up and she did a phenomenal job. And she could do that because Aretha Franklin is a boss. That's what Aretha Franklin is, boss. Now, in May 25th of 2020, we all saw George Floyd killed. My reaction was like everybody else's. It was just an extreme outrage, moral outrage. Watching that sort of brazen misconduct right there on film for the whole world to see, this man died in all of our living rooms. It represented to me like a great existential threat in every way, an existential threat as to the sanctity of life itself, the rule of law. What does that mean? What does equal justice mean? What does it mean, this relationship between the badge that police officers wear and the public trust? What is that to represent? All of it sort of merged in what we saw. The following week, I got a phone call from the Minnesota Attorney General asking if I could help. I had no criminal experience at all. But, you know, I tried a lot of cases in different jurisdictions that are hard. I'm usually busy representing Fortune 500 companies, either trying to preserve their assets or trying to enlarge their assets. But either way, there I am focused on their assets. And I thought, you know, I can do this. I can handle this because after all, you know, when it comes to trying cases, you know, I'm a boss. I said to myself, I can do this. And I've got the experience. And besides, I'm also a Morehead scholar. That's old school. Now it's Morehead-Cain, but I'm a Morehead scholar, you know, that order of green lanterns that exist that can do anything with their power rings. You can do this because that's what Moreheads do. So I decided, you know, count me in. I'll do what I can for this. The case was just that big. I didn't expect to have a lead role in the case. I didn't expect to have a jury-facing role in the case at all. So I can do this. I said, because I'm a boss, right? Well, at that point, then it all happened. The bottom kind of fell out, and personal fear set in for a minute. When I got to thinking about it, I thought you could be killed deciding to get involved in this case. There's a real personal risk. There's a professional risk. When you're in a profession like the law, your reputation is all you have. And you're about to venture out and get involved in the case you have no experience in. So all those wonderful companies you spent 30 years trying to cultivate in relationships could go poof. You could end up as a joke on a t-shirt or a meme for getting involved in this, and then your relationships are gone. And that wasn't all. Then I learned that the case was going to involve real issues of drug addiction as a potential cause of death, that there were going to be comorbidities related to his heart condition and narrowing of the arteries and so on, that were going to be real issues. And then the worst of all, we learned that the trial was going to be televised. Now, as trial lawyers, we like to think we can try any kind of case, but you don't really expect to be put to it by everybody watches. And at this point, I had committed to this, and I will tell you, once I heard it was televised, my boss went from this to this. You can barely see my boss at this point. That I thought, you know, I don't know about this. I certainly had personal reservations, but this case was, to me, was so different in the way it just struck me at the core, at almost a DNA level, that the moral conviction I felt was greater than the sum total of anti-fears that I can think of. And in a way, one way I guess of characterizing is courage is the extent to which your convictions outweigh the fears that you have. And it mattered so much to me to see that there was accountability in this case, that I was going to commit to it sort of no matter what the personal cost and no matter what the implications. And so I just put all of that aside, and I had, luckily, the support of my wife, who said, you know, this is it for a moment and a time such as this, kind of where you made, and this is it. To take all of those, that great experience you get representing Fortune 500s, et cetera, and jurisdictions from, you know, Honolulu to Maine to wherever, and put it to good use for the broader humanity, in this case, doing whatever it is I can do. As it turns out, I was brought in primarily, initially, to help with crafting the narrative in the case, to craft the themes in the case. What is our story going to be and what is our approach going to be? Was the initial outset, and spending as much time as I did articulating the narrative, saying, no, that's not exactly how you approach that particular theme. Let me try to present it again. And by the time I had presented it again enough, they said, hey, we have an idea. How about you do it then? And I said, sure. I had a talk with the Attorney General about the risk that I thought I represented in that way. That if this trial goes south, there is no way that a good part of the blame will not be laid at your feet for bringing in a civil practitioner into a criminal case with no criminal experience. You won't need to worry about me because I will be vaporized as soon as this is over, just poof. You know, why did you ever do a thing like that? I said, but you will be here for the slings and arrows. Politically, you pay a price. And his response was, you know, I'm putting in the best team members I have kind of at each spot, and you're up if you're willing to do it. And so that's how you came to see me. I called kind of what the approach that we took in this a form of conscious leadership, and because it had all the tenets of it. We had a real purpose-driven, inclusive mindset to the whole team. And you could imagine, I mean, this was a unique approach for Attorney General to take. I mean, it is difficult, it is rare to get convictions in these death in custody kinds of cases in the first place. And particularly when you interject the race dynamic, it is extremely difficult. And bringing this team together with special prosecutors like myself, and I think I was the only one who didn't have any criminal background, but there were others out here in private practice who came out of the U.S. Attorney's offices, and et cetera. But the team itself, we all came from, we had extremely different practice experiences coming together. We had different cultural experiences. We had different orientations and experiences and views about police and policing, even. If one of my colleagues on the team had never had an untoward experience with the police, well, that's the ground he stood on. I had scarcely ever had a positive experience with the police. And there was the ground I stood on. I know what it's like to be stopped for no reason, and not just once. And I know what it's like to be randomly selected for additional inspections. Wherever you go, a whole plane full of people lands in Halifax, Nova Scotia, and you are the one who's randomly selected again to go back to the special room for additional interrogations. I know what it's like to be followed around as the person who fits the description of, and you don't know how you could possibly have been selected given that description. I know it. So as Nelson Mandela would say, where you stand in the world depends on where you've been sitting. Well, we sat in different places. And those different experiences were waters that kind of met each other in sort of the brackish way on the team. As we talked about strategy, as we talked about what kind of above surface waves we would see, and then subsurface currents that would be kind of swirling underneath the case. All of the, what I call referendum issues, when we live now in a society of all of these polarizing sort of referendums that people walk around with in the belly. Blue lives matter, Black lives matter. Is the trial a referendum on policing? Is it a referendum on race? And the one thing I was clear on is if the trial became a matter of voting on a referendum, then the prosecution loses. I mean, you are not going to get a group of 12 people unless you can handpick them all yourself and have them make only the 12 people you want who are going to agree across the board on hardly any of those referendums. So it was really important to indirectly and to subtly kind of tease out the things that may cause this to be referendum trials on either race or policing or et cetera, was really important. We had different practice habits. At some points, I sort of laughed with the team. It was like mixing from time to time oil, water, and a bowling ball in kind of how we got along. So we would talk, we would regularly meet, we would talk, we would fight, we would talk, and then we'd come to resolutions. And the result is what you saw. We put on a prosecution that at least I was told was not the way a prosecution would typically approach a case like this. And part of it was it represented our unique team. And I was blessed not to know how they would typically approach it anyway. And we approached it in a way that made sense to us. We took a very holistic approach to the way we dealt with each other. We fought, we disagreed a lot, but this was a team full of individuals who were used to taking charge and being in the lead role in cases. And that meant you had to regard and treat each other respectfully and give each other room. The Attorney General Ellison here would talk about it being a team full of Michael Jordans, he said, which I said, isn't true. There can only be one Michael Jordan. Just ask Michael Jordan. He was in the class behind me at Carolina. So I knew Michael Jordan and we would know Michael Jordans. On the team, everybody was treated equally on the team. That was to the credit of the Attorney General. So that's how we approached our working together kind of as a team. Very conscious in how we approached our different roles, the traction we developed in our regular kind of routine meetings and discussions. I just see David Hart live with Michael Jordan. And me too, we're in the same dorm. It was Granville South back then. The trial was in so many ways, challenging. I could not live at home during the trial. That was not a possibility because of just personal safety risk. I had to be escorted by armed security people everywhere. So if I left the neighboring hotel, which is right next door to my office, and I wanted just to get a notepad at 4:30 in the morning, there would be persons who were armed who would walk out in front of me to look suspiciously down dark hallways to say, it's okay now. And you follow in just to get a notepad out. Courthouse surrounded by razor wire, hundreds of National Guard folks there, et cetera. It was, for me, the most rewarding professional experience I've ever had. Even with the evidence that I felt went in very well and thought it was very compelling. I mean, the fact of the matter still was that there was even a racial divide on what the expectation was on the verdict, that only roughly 40% of African Americans thought, no matter how strong the evidence, that there would be a conviction of the police officers. And that is overwhelmingly historic, knowing how difficult it is. And this isn't the first time that there have been flagrant abuses of individual human rights that everybody has seen, and there was no accountability. Not the first time. So that and not the thousandth time. And so that would be the reason. And so when the verdict came in, I remember sitting there for an hour in the courtroom. So what do you do when you're waiting for the jury to come in? It is the time of the greatest powerlessness that a lawyer can think of, because there's nothing you can do at that point. You just are sitting to wait to find out what others have decided. And my co-counsel, Steve Schlischer, and love Steve, I got to meet him around this. He was fidgeting like crazy behind me, so I could hear him fidgeting and wanted him to stop fidgeting because I could hear him. And I may have written emails to some of you during that time because I was just writing random emails. What else are you gonna do? What are you doing next weekend? I don't know. What are you doing next weekend? And waiting for the jury to come in. And but once we got the verdict and the conviction on all counts, I had a sense of just satisfaction that I had heard a call to serve in this way, to offer simply what I had to serve in this way. I'd heard the call and I'd done my best to answer it. And there was that satisfaction, and I had just an overwhelming emotional sense of gratitude for the Floyd family, because the verdict said that their brother's life meant something, and that it was not just a throwaway. It was heard and watched all over the world. And Chris, you saw it in South Africa, and I heard from persons everywhere, from China to Turkey to Dubai to Peru. I mean, you name it. People were writing in. Overwhelmingly during the trial, I didn't look at social media or the news. I'd occasionally glance at email, because there were hundreds of emails a day from all over the world. Over half of them were on how to try the case. And so that was, that to me, it was fun. It was almost a trial by crowdsourcing, which was unique. you know, some of them had good ideas too. I have to acknowledge that. So that's just my kind of ramp up to how I got involved in the case, a little bit of how the team was organized and how we worked together. The Attorney General, I think, deserves a lot of credit for the courage it took for him to put together a team this way, for him to charge the case out in the way that he did. I mean, this was a very polarized, sensitive, tense environment here in the Twin Cities. We'd already had a riot that had led to the burning down of the 3rd Precinct, the police department here in the city. And everybody was on edge around this trial. So I'll stop there. We'll entertain any questions you want to ask. You know, this is your moment. Well, I may not answer any question you ask, but you should certainly ask away, and I'm happy to share with you what I can.
All right, wonderful. I see we already have a hand up. Who's got their hand up? I need to. It's Letitia. Please ask your question.
Hi, Jerry. Thanks for coming out today. I'm Leticia. I'm a senior scholar at UNC right now. And you mentioned while you were talking about how important narrative was in crafting the prosecution's case. And you also talked about how your team was from a lot of different backgrounds. And I'm really curious, how did sort of this diversity of people with differing views, how did that in some ways clash with the narrative? And how did you sort of bring these two disparate things together, if you can speak to that at all?
Well, it was a whole lot of discussion and confrontation, really, to homogenize. I mean, it just really was. I mean, on the one hand, they would say, you know, Blackwell, you see race behind everything. Blackwell says you don't see race behind anything, and it's a real thing. And so we'd have to hash it out and argue about it. I mean, some of the most fundamental things. I'm told that the typical prosecution case would begin with providing some background about the victim, that you would learn kind of who George Floyd is or was, and something about his life, and that's called a spark of life witness at the start. That was a real discussion. That, for example, to me, didn't make sense. I mean, George Floyd isn't on trial. So why would I start off talking about George Floyd and make him the focal point when he's not on trial? And so that was a real discussion that was sort of messing with the feng shui of the career prosecutors. I was concerned that there would be things in the trial that would be tropish, that you would hear he's big, he's scary, he's drug crazed, that even when he hadn't had a pulse for 4 minutes, he could still revive, break his handcuffs, and rampage the whole city. If that's not a trope, what is? That's not describing a human being. That's describing a beast of some kind. And so this I expected to hear, and to them would say, hey, we have to do certain kind of rebuttal in the narrative. Not directly, you don't call it out, because in Minnesota, we don't behave that way. I think we have a good Minnesotan, along with myself, one here, Mark Jacobson, that I've known for forever. Minnesotans don't behave that way. We are very genteel and don't like a lot of spice. Here we think butter is a spice in Minnesota. So you don't do that. But what you do, and what we did, is brought out the humanity at every step of individuals. It was important that you actually get to know the bystanders, for example, so they couldn't be characterized as an unruly mob. When we talk about drug addiction or drug addicts, it was clear that we're not simply describing a lesser kind of individual who is a beast who terrorizes, but really somebody who needs medical care and treatment, that it's a condition. And you heard George Floyd's girlfriend, Courtney Ross, talk about that. That was very deliberate. Having the children, young adults testify was extremely important for humanizing. And that was all kind of very important for bringing out the humanity to try to overcome any of this sort of human objectification that might exist in the minds of some of the jurors. That was a result of a great deal of debate and back and forth within the team, and evaluation of what the risk would be of pursuing any of those types of testimonies.
Thank you.
Sure.
Bill Lucas has a question for you. Bill, are you able to ask your question on camera?
Yes.
Right.
You mentioned in your remarks that you had approached this trial in a different way than had been the norm. And I was wondering if you could elaborate on that.
A couple of ways, and probably not talking out of school. We had drop-in visitors during the trial regularly in our team meetings, and one of them was Barry Scheck, who would come in. Barry Scheck, now of the Innocence Project, and formerly a science counsel, at least he seemed to be one, in the O.J. Simpson trial. And his comment was, we, meaning criminal lawyers, are taking notes on this trial because it's not the way we typically do it. And it wasn't just the order of the witnesses, it was specifically the focus on the medical causation case, that in so many prosecutions, the proof on medical causation issues is simply to put the medical examiner on the stand and push the play button. And what the ME says is the medicine is the medicine. And here, as a civil practitioner, we'd never do that. There'd never be such a thing as what I call an omni expert who is going to testify about pulmonology, cardiology, respiratory physiology, and all the rest of the ologies. You would call those experts, you would layer it, and it's very important to do it because you can't always be certain where the medical examiner is going to come down. And you've got to make sure that the jury has a solid embrace of the key points of medicine, that we've got to first understand it on a detail level, to pan the camera back at 30,000 feet so that it's plain and understandable and accessible to jurors so that they can understand the medicine and feel that they own it. And then be prepared to take on the defense medical expert. And I'm told that that prosecutors don't necessarily get a lot of practice with cross-examining other medical types of folks. And the approach taken to cross-examining their medical expert, Dr. Fowler, a lot of them found that to be unique too in the criminal realm. I had my own demeanor, which I tried to keep fairly factual and not very emotive, and that's very intentional for Minnesota. I would maybe different in certain parts of the Bible Belt, but here it wouldn't. That wouldn't play in Minnesota. But even with that, they found some of the prosecutors said, hey, the way you approach this, and even saying things like the final line about George Floyd dying not because his heart was too large, but because Derek Chauvin's heart was too small, was the type of line or approach that's unusual for prosecutors, I was told. To which I could say, I didn't know that. So it's what we would do in civil world. So those are some of the examples of ways that it was different.
Thank you, Jerry. Next up, Evans Witt has a question for you.
Thanks so much. So far, are we getting you? Yeah. Thank you so much. It's been a great discussion so far, Jerry. I've learned a lot. But I have a question, not from me, but from my wife, who's a retired lawyer. So I'll hand her the iPad.
Well, all right then.
Hi, Jerry. My name's Amy, and I'm a retired white-collar criminal defense lawyer in Washington, D.C. I followed every word of the trial, and I just want to say that the performance isn't the right word. Your professionalism was just incredible. The fact that you humanized George Floyd the way you did, I think made all the difference with the jury. But my question is, how did you persuade all the police officers, including the police officials, including the police chief, to testify against officers?
Right.
Thank you.
There is a hugely important component of this, or two, that I didn't talk about, and one of them goes to your question. And I didn't talk about Police Chief Madera Arredondo in Minneapolis. A few things that were unique. Keith Ellison is the first African-American Attorney General in our state. Chief Madera Arredondo is the first African-American Chief of Police in Minneapolis. The officers who stepped across that blue line is owing overwhelmingly to the leadership of Chief Arredondo. From the time he saw that the video, what he saw in the video, I think really surprised him, because the accounts he had gotten up to that point did not reveal to him that had been this type of force that had been utilized. And he had gotten the sense that George Floyd had simply had a medical event during an otherwise uneventful arrest. So when he saw the bystander video, the Darnell and Frazier video, he was shocked, and he called it out immediately that this was not good policing. This was bad policing, and there was no authorization for that under any training, any approach, any policy, anyhow, with the Minneapolis Police Department. It was Chief Arredondo's stepping up as the chief and
Is Jerry frozen? Brother, so, all right,
Yes.
okay. We'll give him a moment to recover. All right,
I think his Wi-Fi couldn't handle the box.
no, I think, hold on, I'll send him a quick message. We've sent him a message. Let him know he's frozen.
I think he's just logged out.
have I returned?
He's back. Welcome back, Jerry.
Yeah, you missed the best part. It was really Chief Arredondo, though, who made the difference in the other officers stepping up. And I thought the other officers testifying was more important than what any use of force expert had to say about good policing, and far more credible to the jurors was the fact that other officers stepped up. And I wish they would just follow the playbook of lawyers. I mean, you can turn on the television every night on every program, find 5 lawyers willing to criticize some other lawyer. And I mean, there is no hesitation in it. And any night, any day of the week. And my hope is that other police officers would be inspired to stand up, to call out bad policing as in the best interest of good policing.
Great, thank you, Jerry. I had promised Asher Wexler that he was next, but I just learned that Roy Flood has to leave in a moment and he has a question. Roy, will you quickly jump in? Asher, you'll be right after Roy. Got it, Roy? Oh, here you go. You're muted. There you go.
Okay, now sorry about that. So Jerry, you mentioned some of the personal and professional challenges about this. I'm just wondering how you coped with this, devised a strategy, et cetera. Did you speak with any attorneys or colleagues from other high profile trials like Christopher Darden, for instance, comes to mind? Just how'd you get through that part? You know, I think it's very plausible to be concerned about your safety and your family's safety, et cetera.
No, Roy, I really didn't. I mean, my reaction in getting involved in this trial is more akin to an excited utterance. You know, it's the one time in my professional life where I like to say I jumped from the diving board first and checked for water second. You know, this is a thing to do, and I am in on it. And it was only after I sort of committed to it. You know, I kind of think in every one of us. I mean, there are abilities that you have, aptitudes that you have, responses that are kind of built into you that you don't even know about until the circumstances present themselves. And when they do, it's like something is activated within you, something is triggered, and you just start marching north. I mean, this is kind of what you're designed to do. It felt that way. And so I didn't call anyone. In fact, I had some trepidation about going home to tell my beloved, my spouse, what I had decided to do. Not decided, what I had declared that I was going to do already, and then to see if I could get her imprimatur and kind of skip over that part that I didn't really discuss it ahead of time. You know, it's could be a problem. And she supported it, but I didn't do any reach outs for that kind at all. Practically speaking, I mean, I've been in quite a few trials, and the thing about representing Fortune 500 companies in major litigation, I don't think I've ever been in a major litigation involving a company where you always discover they're either going to have bad histories or facts to deal with, or bad witnesses, you have bad documents. There's always things like that that are difficult, and they almost invariably in bad jurisdictions. And so that's my universe. And almost all the cases are sort of at the intersection of law and medicine. So the medical aspects weren't totally foreign to me either. I think the Attorney General felt that experience would be useful in a case where there'd be difficult issues. And I never think of juries as either criminal juries or civil juries or antitrust juries. It's just a jury. And if I could kind of get equipped with the rules I need to learn, procedures I need to learn, then doing the two-step on having a compelling narrative, a case driven by themes, it should work. But long answer to your short question, I didn't reach out to others. That would be a very rational, analytical approach. But this was on a different order for me entirely. So it just bypassed all of that, you know, that this is what you are going to do, you know.
Great, thanks, Jerry and Roy. Great question. Next is Asher Wexler, class of 25. Thanks for waiting, Asher.
Yes, hello, Jerry. Thank you so much.
Hi.
I wanted to ask about any certain like legal technicality that you were worried about. There was obviously overwhelming public support for a guilty verdict. And then like I thought I knew what the verdict should be. Was there anything that you were worried about? Any like O.J. Simpson factor, any crucial point that you had to make?
No, no, not really. I mean, if you watch the trial, you can hear certain points. The trial judge was threatening a mistrial if you do this or if you do that. I'm going to declare a mistrial. I didn't want to push the court on it. I was wondering if he would really do that in this kind of case, but I didn't want to push it. To the extent I had any kind of resident concerns, they were mostly from my colleagues on my team who were saying, make sure you don't say anything that's reversible error. So there was their concern. If you're not a criminal lawyer, there are a great number of protections for the defendant and defense counsel in ways you cannot or not allowed to characterize them. If you remember even the closing arguments and rebuttal, I was talking about the story that they had been told by the defense lawyer. And there was an objection that I cannot use the word story to characterize what they had heard from defense counsel, Mr. Nelson. And I said, wait, didn't he just refer to our case as preposterous, ridiculous, and nonsense? But story is a fighting word? I mean, boy, it's got 5 letters, not 4. And but it was a judge's call, judge's discretion, and said, no, you can't characterize their case as a story. As the defense counsel argued, to use that word was belittling the defense, which the prosecutor is not allowed to do. And my view was, if the defense counsel felt belittled, it wasn't because I used that word. It was something to do with the nature of his case. But I left it alone. So my concerns legally were just making sure that I stayed within the hash marks of what can and cannot be said as a prosecutor in characterizing a defense case. And it was more so that than being worried about any evidentiary ruling as the case unfolded.
Great, thanks, Asher. Next, Buddy Wester.
Thank you very much. Sherry, this is quite something to take in. You referred to the frequent or recurring debates among the legal team in which you served. I'm reminded of the phrase, if you have two lawyers in the room, sure you have at least three opinions.
Mhm.
What were the lodestars of resolving those disputes, things you're going to put on and you all are contesting what you're going to do? What made the decision which way you would go, what strategy you would follow?
Well, ultimately, the Attorney General. It was very interactive, and sometimes there just had to be a call made. It wasn't either clearly right or clearly wrong. There's ultimately a question, what are we going to do? And the team has hashed it out and rehashed it and argued some more. I mean, phenomenal discussions. For me, it was a highlight to be on the team arguing with Neil Katyal, for example, and who's now surpassed Thurgood Marshall, even for the number of cases argued before the United States Supreme Court. And so we would hash it out and go back and forth, and then over sometimes weeks. And ultimately, the Attorney General makes a call. Where do we start the narrative, for example, was one of those calls. And there was a view that maybe we should start the story chronologically, which would be the typical prosecution way, that on May 25th at 8 p.m., George Floyd went into Cup Foods and blah, blah, in a chronological story. And the other view was that we should start in the middle of the action with the 9 minutes and 29 seconds, start at the 9:29. And you can see how that was ultimately resolved, even from the opening where I started in 929, the three most important numbers you were here in this trial, 929. And that was one of those things. And there were many of them. We met every week for a year, and we had subcommittees that also met weekly for a year. So there was quite a lot of work and a lot of hashing that went into it. And it's hard to kind of characterize it, even though you'd sort of duke it out in the meetings. There was kind of overarching sense and satisfaction and an understanding that everybody is simply trying to put on the best case. And within those confines, have at it. But ultimately, if a call had to be made, then the Attorney General would make the call because he was there running all the meetings, all the week.
In the middle of a cross-exam, you can, or in direct as well, but you can get, how shall I call it, a surprising answer from the witness, and you don't have time to huddle with a group. That was just left to each of you to run as he saw fit.
Oh yeah, because what do you do at that point, right? You are, this is it. You're in the ring,
Did you think you were leaving the themes or vetoing any decision when you were doing that?
No, not at all. It is, the truth be told, I don't think I've ever been in a trial that went to verdict that on some level didn't turn on something that nobody planned. I mean, there's something a witness says from the stand, there's some ruling, there's always some kind of a curveball of consequence that nobody thought of it. Dr. Fowler, for example, the defense expert, was commenting on the fact that despite that George Floyd didn't have a pulse, that there was a window of time where he was still revivable. And I thought, oh, I didn't expect him to say that. And well, since he did, well, doesn't that mean he's critical of the police officers for not making the effort to revive him? Well, what's he supposed to say if he's a medical professional? And admitting to that, went part ways to an element we had to establish, that he found himself, their expert, being critical of them, the defendants, including Mr. Chauvin. Didn't expect it, is what he said from the stand, and so I just followed it. Other things, I think, well, what do you do with this? I mean, toward the end of the trial, carbon monoxide was made an issue, as in perhaps to the extent George Floyd suffered from low oxygen or asphyxia, it was from carbon monoxide from the tailpipe of the squad car. I didn't expect them to make an issue of that. And once they brought it up, it's one that had me scratching my own head, because I couldn't figure out how that helped the defense. And you can't obviously arrest somebody and as part of the arrest, tie them to the back of the squad car and drag them through the street. You can't do that. I don't see why you'd be able to arrest them and then put their face by a tailpipe and then somehow excuses the police. It wasn't me, it was the car that did. But as it turns out, it was a hybrid vehicle and they didn't even know if it was owned. So it was, where's this gonna go? So some of that, you do your best planning, make your best preparations, and you got a play to be called, but every once in a while, the other team is going to blitz and you got to scramble. And you try and make it work. And that to me is just part of the dynamics of trial. But I didn't feel we got off the themes that way. And I wasn't calling in sort of counter plays.
Thank you.
Jerry, thanks, buddy. Great questions. Jerry, just checking your time quickly here because we've got about 5 or 6 other hands up, folks who want to ask questions, but I'm sensitive that we're coming up on our time. So do you have time to stick around and answer some more, or how do we want to?
I can stick around until a quarter past the hour if people want to.
Wonderful, good. Well, we will proceed and see how far we get and how things are going. Mary Long is next with her question. I'm not hearing Mary's. Are other people hearing Mary? Did I lose her?
There we go. There I am. Sorry.
Okay, thanks.
Like muted. Shout out from the class of '84 to Jerry. Jerry, we're very proud of you and what you've accomplished with this. It's just amazing. You previously noted how acrimonious the trial was, the bizarre twists and turns. And yet when you gave your remarkable closing arguments, you were so calm, cool, and collected. You were so approachable, like we all know you are. But Jerry, what were your thought processes and your goals, your criteria when you planned that argument? What went through your head as you were trying to figure out what lasting impression you were going to leave on the jury?
You know, Mary, I would say when I think about components of trials and which ones mattered most and which ones I really wanted. I wanted the opening statement. The Attorney General had said, you know, you will open and you will close. And I wanted to work in Steve Schlischer. And so Steve took the bulk of the closing. I wanted the opening for starters because that is where you first start getting the commitment from jurors, their understanding of the case. To me, it's far more important in a sense than the closing, although the closing can be more exciting. The second part, though, is the rebuttal, right? That you're talking about, because the rebuttal is all improv, you know, at that point, because you don't know what they're going to say, and you've got to be ready to just kind of get in the trenches and try to kind of bring it back around again to your themes and so on. And so I did not expect, first of all, for that closing to go on for hours. So that was my first zinger. If you could see that jury, they looked like plants wilting under a heat lamp from the amount of talk they had gotten. So I knew in the closing that I needed to be brief, first of all. You know, how are you going to kind of take on a closing that's this long and then be brief, relatively brief in the rebuttal? And it's taking rifle shots, you know, that I want to poke holes in the credibility of some things that were said. And I want to end on something that's an overarching point and theme. They had so focused on his comorbidities, essentially arguing that he is dead because of him, because of his drug addiction, because of his cardiac comorbidities, his struggle, etc. And I wanted to end on something that would be an emotional, impactful statement that would both get at the excessive force and the question of medical causation, and to find a way to do it in just a sentence, right? And so the break that we had between their closing and rebuttal, I kind of went away to myself to kind of think about what that might be, and that's where the thought occurred to me to focus on the whole heart issue, because there they focused on the heart anatomically, And I focused on the heart as a matter of moral and ethical conscience. And it sort of blended them together. So it was, when the closing was finished, there are moments as a trial lawyer where you feel like you're faced at the bottom of a well, just looking up like, oh my God, this is, there's so much here to kind of work with for the rebuttal. How are you going to pick and choose? And you just take a deep breath, center yourself. The meditation I do help tremendously, I will say, to keep me calmer and focused, and think about what you want to end on, and take rifle shots to make certain points with the jurors. And so, Mary, I don't know how to more directly, precisely answer that, other than I was clear about where I wanted to start and I was clear where I was going to end. And I didn't want to end on, the lawyer typical. I want to thank you all so much for being so attentive. You've been a wonderful jury. You've been which is, the typical lawyer. I wanted to have an ending that was a drop the mic statement and just make the statement and walk away, was the goal.
You succeeded brilliantly.
Good to see you.
Good to see you too.
And so we interned on the West Coast for one summer. I'll never forget it. So
I'm thinking about governor's school, so.
Oh, that is right.
Yeah.
My goodness,
Yeah.
alarm. Yes,
Yeah.
that's true.
Long time ago.
I even had hair then. That's really something.
I wasn't gonna
Thank you, Mary. Jerry, we've got another sort of
sure.
mid-80s friend. Andreas Stumpf is next.
Oh, yeah.
Hi, Jerry. Yes, another voice from the class of '84, and it is so beautiful to hear you. I've been so looking forward to this.
Good to see you.
I have to admit that I have had, throughout the trial, I had such a swell of pride every time, thinking that, I knew you and that you were doing this, and honestly lived through you vicariously at times when I was feeling very helpless about what to do about these injustices in the world. So it was really so wonderful to have you do this. And listening today, it just is even more impressive as to what you accomplished and how you went about it. So I should have a very kind of serious question, but honestly, we're all commenting in the chat as to how humorous you are. And I guess what I'd like to ask is, how did the humor help you? Or maybe you've gotten more humorous over the years. I kind of forgot, but it may just be life that's done that to you. But did the humor, did you use the humor in ways to present the case or to connect with the jury? And maybe I should ask, knowing the backstory now, with your peers when you were having these drag out fights on how to proceed. It's been wonderful, a wonderful part of hearing you today. So thank you. Thank you.
Right. No, I don't think my colleagues wouldn't usually call me humorous. They go, oh, him again, And he's starting up again on the same thing. If he brings up Brady Giglio one more time, we're going to strangle him. And so them, not so much. But in front of the jury, to me, it's just talking to a jury in general. The goal for the trial lawyers is how do you get to your most authentic self, and your best authentic self, just to be naturally who you are. It's not a trial that really left a lot of places in it for humor, given the nature of the subject matter. But if and when there was, I was just trying to just be who I am, kind of in the moment, and naturally it does help to diffuse. It helps to keep the tensions down, and there'll be aspects in the trial. I mean, when some of the craziness, this question that if we didn't have the video footage, what would you have concluded that George Floyd died of? What was the question? And so I thought the proper rejoinder to that, isn't that like asking Mrs. Lincoln, Mrs. Lincoln, but for that John. And so before I could get it out, they jumped up to object. The judge would let me say it, but it had already been said, that Mrs. Lincoln, because that's craziness. You mean, if I didn't see this poor man pushed out of the window on the 50th floor, what would I've concluded he died of? I saw him pushed out of the window on the 50th floor. What are you asking? Exactly. And so it was to call that out and in a way that was quasi, humorous, making comments about Mrs. Lincoln. but for me, it's just all a part of, for me, just how I roll in the world. That there's humor in most things. So
It also reflects on your level of confidence, and I think I like the authentic self that the way you describe it, that it makes it so believable or credible or gives it a different force. So I'm appreciating it today.
yeah, the one thing I'll say, at least for me, and the benefits of meditation, if I might put a plug in for that response to the question, you do get a different vantage point just on your own self when you practice meditation, and it's humbling at first because you think, oh my God, that is me. And then you come to realize, at least I have, that there's nothing I really see and recognize in another person that on some level isn't within me too, or I wouldn't recognize it at all. And it helps me as a trial lawyer in that when I'm talking to jurors, I never see them as strangers, because anything that I perceive in them, I see as more or less some reflection of something I have too. And so it helps me be more relaxed in talking to them, because I don't see them as strangers. And I don't feel a need to have this kind of false perfectionism that some lawyers do. They put so much pressure on being perfect in every word, every hair, every piece of paper. And the way they do that is by dumbing down and boring down the case. And so by the time they're done, it is so vanilla that it oftentimes bores the jury. And I just say, hey, find the most authentic you, and you do that by getting on your feet a lot, speaking a lot, presenting a lot, and things will happen to you when you do. PowerPoints won't work. You will find that there are all kinds of other bizarre things. People interrupt your speeches. You occasionally have a wardrobe malfunction. Things happen to you, and then you survive it, and then you realize you're okay, and you survived many of these sorts of things before. And it makes you more comfortable getting up, talking in front of a jury, even in a case where you're aware everybody's watching you. You just tune that out and just go on eating your pizza, so to speak.
That's so beautiful. Will you write that book, Jerry? And we will get just all about your philosophy, and we'll get Tom Morris to review it.
Well, that would be great, and you should write it and have a byline. But that I would appreciate.
Thank you, Andrea. Another near classmate, El Chino Martin.
Oh,
hey, Jerry, after many, many years, we go way
many, many years. Yes, from the time I was in the 8th grade. El Chino.
I know, it's remarkable. Great job, terrific job. Getting back to your Mrs. Lincoln moment, that was actually my question. If we did not have the video, given all the other testimony and all the other witnesses, do you think you could have obtained a conviction given the composition, the backgrounds of your particular jury?
Could have been difficult without the video footage, and I think that technology is a tremendous game changer. If you follow the trial closely at all from the beginning, or at least the narrative from the beginning, the storyline, the initial reports that were coming out from the police spokesperson didn't admit to any of this. If you had read it again, you thought he just had a medical event in the process of a normal arrest. And it is the video footage, particularly of the bystanders, that to me was tremendous. I'd like to think that even without that bystander video, we would still have the police body cam footage, but I don't know that. I don't necessarily trust that. So I think, man, that video footage was tremendously important. It is still true that a picture's worth 1,000 words, and then what's a video worth? At least 1,000 pictures. And having that video footage to me made all the difference in the world, because it was the rejoinder for every expert who got on the stand who said X, and we could show the video footage and you could see that it's Y. You can look at the video footage and see, for example, when there was an anoxic seizure. You could see when his oxygen levels were so low that this is the evidence of brain injury. And we can show you how the involuntary reflex in the body from the video footage. So it was critical for medical causation. It was critical on use of force, the excessive force aspect of the case, to have that footage. And without it, I don't know. I think it could have been a lot of they say and we say, and we might have been left with whether you trust or distrust the police, because all we have are just the words.
Thanks.
Question, Chino.
Yeah.
Thanks, Alcina. Great. Two scholars together next. Jerry, we have Monty Evans and Charlie Tran together.
Well, this is serious Green Lanterns, huh?
Hey, Jerry, thanks so much for coming on and walking us through this. I know for those of us who are not involved in the legal world in any way, the trial itself is kind of like iceberg, you can see what's going on the surface, but there's all this, stuff happening underneath it. You have no idea what it is. It's very helpful to have you kind of pulling back the curtain on that. My question is around sort of what you feel are the sort of knock-on effects of the trial going forward. Because there's only one Jerry Blackwell, but there are obviously continuing instances of police violence in this country. And I'm wondering from your perspective, how, if at all, the trial has changed the way that in the future cases like this will be prosecuted when there's less of an international spotlight on things, and when there's not such a sort of crack team of lawyers around the case. If we're in a small town in Arizona this year and there's an instance of police violence, do you think this trial has made it easier to reach convictions in cases like that, or will be sticking in the mind of people? And how do you think those will have changed, as opposed to, as you said, the expectations in the community with the cases like this didn't typically lead to convictions in the past?
Yeah, I should respond less in terms of what I think and more in terms of what I'm hopeful for, and I'm hopeful that that other police and police officers will be inspired by the example of Chief Arredondo to step across the blue line. I'm hopeful. I spoke to an association of attorneys generals maybe a month ago, and encouraged them to consider in strategic cases doing more of the public-private partnership, because I'm the only sort of Jerry Blackwell sits in this skin, but how many other individuals who are better than that, who sit in other skins, and that they should consider that in the right strategic kinds of cases, to have the public-private partnerships. And I just tend to think that the progress we make on social justice issues, on issues of equity in the law, oftentimes is incremental. I mean, it's not a, when I was after the verdict, I was standing in the hallway with the Attorney General, and he said, somebody wants to talk to you, and he hands me the phone, and the person says, this is Vice President Kamala Harris. And the next 7 seconds, I don't know what she said, because I was like, man, Kamala Harris. And but her point she got to, she thought the trial was an inflection point in race and policing. And I listened to that, and I thought, I don't know about that. I don't know that they're really inflection points. The idea that the way forward will be easier than the way to this point. And when I think about justice issues in general, when I think about your question about what this will mean for prosecutions in the future, I think progress doesn't move like a wheel on smooth pavement. It moves like a brick on rough terrain, full of potholes and switchbacks and inexplicable signs. And when there's progress, the only question I have is, were you able to flip the brick? Even if it's 1 turn, 2 turns, 3 turns. We keep flipping and eventually you get off this ugly, the ugly badlands. But it is, to me, the continual perpetual efforts to flip that brick. And I don't subscribe to either silver bullets, and I don't think I subscribe to inflection points either. Does the fact of that verdict to any degree inspire others to approach these cases in a different way, to have district attorneys charge them out properly, to have police officers step across the line, to get private practitioners willing to stand up and be counted, even though they're not criminal lawyers, but have skill sets that could be useful. Broadens the perspective of the public so that more members of the public are more receptive to the idea that there are bad police officers out there who should be held accountable. And if the trial helps to any degree in those areas, then I feel the brick has been flipped, and it is worth it. So that's the way I think of it.
Gotcha.
So just-
Thanks, Jerry. I appreciate the honesty and the optimism there.
Thank you.
Thanks, Monty and Charlie. So two more scholars have their hands up, but I'm sensitive that we are right at your time. Jerry, do we want to try to connect you with them offline, or are you willing to try to do
Well,
quick answers?
I will do quick answers.
Okay,
which
very good.
I'm not sure I'm capable of, but I'll try.
Becca Siegel is next.
Hi, Jerry. Thank you so much for taking the time to speak with us. I'm a first year at UNC, really excited to be here. While I was watching the trial, one thing that was really compelling to me was specifically the testimony. I believe she was either 9 or 10 years old, and I was just wondering if you could speak to what it was like to work with someone so young in that context, especially after such a traumatizing event, and what it looked like incorporating that into the overall trial.
No, thank you. It was a risky proposition, obviously, a very young person. We put her on the stand. If she crumbled under sort of the pressure and the weight of this, then it's a pretty bad optics for the prosecution for that to happen. On the other hand, from the mouths of babes, that what a better statement about the humanity of the so-called unruly mob than a 9-year-old girl with the word love written on her t-shirt is a sort of real statement. And even a 9-year-old knew what the proper behavior was here from a policing point of view. You didn't need a PhD, police training, or the rest. You just need the consciousness and heart of a 9-year-old who knew what to do. You know, get off of him, she said. Or as she put it, somebody should call the police on the police, she said. And but preparing her was tricky. She liked snacks. She was on the way to Cup Foods to get snacks. So when I met with her to prepare her, I had snacks. And she was, we broke the ice pretty well early on. She came with her guardian, and she had grown several inches, and I noticed it. I said, "You've gotten much taller." I said, when I was coming up, I was always hoped that I would be tall, and I got to be 5'9". I didn't get to be the tall, striking, handsome person like my roommate back then, Jonathan Reckford, I stopped at 5'9". I didn't get to be tall. And she said, well, you're not very tall. She said, but you are wide. And so that got us off to a good start. And I told her, you can just go sit over there. And that's how our prep started. It helped her to relax. And I told her that if she could behave better during the interview, she could have the snacks at the end. Otherwise, you can. And so it was getting her to be calm, calibrating to her as a 9-year-old and getting her on and off the stand quick, so that we just simply made our point about how this had affected even a child, and even the child had the sensibilities to know the right thing to do.
Thank you.
Thanks, Becca. And last but not least, Hudson Shank.
Hey there, Mr. Blackwell. Thanks again for taking the time to speak with us today. Quick side note, I'm actually sitting in the second floor lobby of Granville South right now. So I thought it was quite interesting to hear that the Jerry Blackwell and some guy named Michael Jordan shared this same space some time ago.
But back in the day, by the way, they had pinball machines downstairs, and everybody had their own quarter that you would put dental floss and super glue around to kind of, and to keep reusing it. I'm just saying.
Quite different now, yeah. But yeah, one thing I thought was quite interesting about this case, especially, was the national outcry that sort of came from the press and mass media to sort of create an entire movement rallying around justice for George Floyd. How, if at all, did this sense of national attention and outcry sort of impact the case in the courtroom and even behind the scenes? And how do you believe this case might have been different if this additional element was not present?
For me personally, I was very intentional that it didn't affect anything, because I tuned out to all the news and social media, et cetera. To the extent it ever somehow bled into the trial, it was always a problematic element that the jurors had taken an oath not to see the news and not to see and view that. And to the extent there was a concern that jurors had somehow been exposed to things like the $27 million civil settlement that took place in the middle of the trial, well, we had the separate polling of the jury just to see to what extent anybody had seen or was aware of it. to keep that out of the courtroom. There was a second part to your question. You wanted to know how did it?
Yeah, like just in general, how did it maybe change things behind the scene, and like how would it be different if this element was never present?
Yeah, I think that from the standpoint of trying the case, not different. If anything at all, the fact that there was so much publicity about, and the video footage was just so compelling and poignant, it probably affected jury selection in that it was harder to find jurors who didn't have preformed views, given just how emotive the videotape was. And so I'm sure there were jurors that we would love to have had, but they had seen enough to know exactly how they feel about it. And we're pretty clear that this is kind of how I feel about it. And it meant that there were certain jurors you couldn't have. It was true on the other side too. There were some that came in that were had their own kind of ideologies that said, I see this and there's no way I'm ever gonna hold a cop accountable. So those jurors were out too. So I think that was Mr. Shank, the direct answer. I don't think it bled into the trial. And we did everything we could to keep it out of the trial. So Mr. Hart, by the way, is asking how confident were we in the verdict before it arrived. I felt like waiting for the results from the bar exam. You think you passed. You feel like you should have had enough, but until you've seen it, I don't know. I felt that the jury had come back so soon. The jury was back, was 2 days sooner than I thought they would probably be back in the case, given my infinite wealth of experience as a criminal lawyer. But I thought that they would have been back a couple of days later. So the fact that they came back so soon, I thought probably meant that it is it's a verdict for the prosecution in the case. And as the jury walked in, I try to do the usual thing trial lawyers do, is to try to read and guess what the jury has done by who they do and don't look at walking into the courtroom. What do you make of that? So as a result, Mr. Slisher, my co-counsel, and I both were fidgeting in our own ways because the last thing we were certain what the jury would have done. So
Right. Wonderful.
It's been wonderful speaking with you all and seeing friends that I haven't seen in such a long time. And all I can say is they look like they haven't aged at all. And I certainly look to me like I have. So it's
well, we cannot thank you enough. Jerry, you have just given us a great opportunity to come together as a community and learn from you and your experiences and enjoy your incredible sense of humor, which I think was a big surprise, even for some of your friends, how funny you have remained and become. And you really do exemplify our Morehead-Cain values of leadership and moral force of character. And we appreciate that you have made us so proud.
Well, thank you all. It was a delight being able to talk to you all, and it's not every day you get to speak to the Order of the Green Lantern. So I was happy to be able to address you all.
Thanks again. And listen, we hope you'll all come to your decade reunions and the mini forum, and then definitely return to Chapel Hill next October and see Jerry in person. Can't wait to see you all there. So take care. And as I said, if you want to write a little thank you note on the way out the door, we will export the chat feed and send it to Jerry so he can have all of your comments.
Thank you all.
Thanks.